could speak to insofar as being problematic. The grass, even at that time, 2 weeks ago, 10 days ago, was substantial, very few bare patches. I saw no reason to call the property anything other than stabilized, but that's my view. I think Catherine agreed with it. I don't know, Tim or Richard, did you get out too?
Yes, I did.
Okay, in your opinion?
It's same.
Same?
I concur with you.
Okay, so to me, whether or not, and John, I don't know what our obligation is here in regard to the stop work order, but it does seem like a moot point to me, insofar as what the alleged violation had been.
Okay, well,
It's my own.
the substance of it, so there's a separate question. Mr. Nemmers is asking, he's presenting the question to you whether the stop work order is valid, given the way that it's drafted, okay? And then the second issue that's being presented is whether, if it is valid, does it apply to number 6 and number 9? And there's the separate issue, which is still ongoing with the new zoning enforcement officer, as to whether or not the remediation efforts have progressed to the point where maybe the CEO decides that stop work order, it's not necessary to keep that in place. And I don't know the answer to that question. Now I forgot what the original question was, but that question about whether the sufficiency of that remediation isn't really what's being presented to you.
But as of yesterday, Mr. Trimble advised us to continue with the zoning board in the hope that you could make a determination that either that this, as you said, the first question, whether this is a valid stop work order, and if it is, secondly, whether it applies to the other two parcels. If it doesn't apply to those parcels, we're fine, because we can then go ahead with the construction on 9 Charles Street.
Yeah, and I did speak to Michael about this, and his concern is is the precedent that's been set by the action that's been taken by the zoning enforcement officer with regard to
Extending the stop work
both
order.
issues, so.
Right. So should we be discussing this with the other board, or how do we?
No.
No,
this
it's our province. We have to make a
It's your issue to
determination.
decide.
Yeah.
Okay.
I have a suggestion as to how to move forward. I don't know if there are other people that are here to speak to this issue, but you may want to conclude taking testimony before we start talking about next steps.
Right. Is there anybody here who is, I assume Mr. Rodenhausen is going to be the speaker for, unless, Mr. Nembers, you would like to speak?
Quick comments, some of which are not really part of.
Speak into the mic.
Yeah.
A couple of points, several of which are not really before you, but they need to be made because I've heard these comments from a lot of people who've had trouble with zoning in Rhinecliff particularly, who've come up to me at farmers market and other places saying that they've just had terrible problems with zoning. There's a reputation that's getting built quite deeply that zoning in Rhinecliff is, and maybe in Rhinebeck, is not good for the people in Rhinecliff. I've had several people say they've decided not to do things because they didn't want to go through it. I certainly felt like I was treated not by either the planning board and certainly not by you folks, that I was the bad guy, that I was doing things detrimental to Rhinecliff. And the whole point, first of all, redoing the house kind of stands on its own. But the bank, we got all kinds of negative comments on that from the zoning enforcement officer. We did that in the first place because the weeds were awful. They were poison ivy, they were sumac, they were lots of ailanthus. And the point I want to make is that if the zoning officer had called me, or, well, no one else was involved in it, if he'd called me, I could have told him what we were planning to do And it would have been the same things that he was demanding in the stop work order. It wasn't necessary to do the stop work order. We would have told him I was going to hire the same people that I had to do under his demands. He wanted us to get experts. We did. And then he said later on that he didn't think he could accept the opinion of our experts. So it's been just a really terrible situation here that we've not had any work done on the house now since June 28th when we submitted the plans for the planning board to consider. And we've lost the summer. We almost lost saving that bank because there was first of all, there was an odd coincidence of we were about to start planting grass first and then decorative plants. And then we had that wonderful spring, lots of water, and then the drought came. And right after or about the same time as the stop work order. So we couldn't do anything for a long time. And it meant a lot of extra work, a lot of extra cost of getting water to their sprinkler system set up. It's just, if we had been asked in the first place what we were going to do, we could have resolved his issues immediately. There were a few issues about whether we were on a paper road. Actually, the town attorney said he was quite happy with us putting nice plants on. We would have hired Heather Whitefield and her group to do a lot of the work on it. This has all been a lot of expense, a lot of time for us, and it was all unnecessary. We did get a question today even. George's partner, Victoria, had called Michael Trimble, and he said he thought he would be able to sign the permits, which had been approved on August 21st by the planning board, if we could tell him whether the grass that was planted was perennial or annual. Okay, one that we had no notice except for today. I did get a call from Heather Whitefield, who did the supplemental planting. We originally had Loveland Landscaping do it, and she supplemented it and had been taking care of it and watering it. But she did say late, and that's why I was late getting in here, that it was, I'm not sure I'll find it here, it was a combination of two different perennial grasses with some annual grass thrown in just to do a buffer to get things going. So I think Michael will be happy to hear that. But it's just, I've been a lawyer with federal enforcement agencies for 30 years, and I don't think I've ever been treated this way, like we went through, and the cost and effort to do things that we thought were just normal community things. And I've heard this same comment from a number of other people I didn't know who came up to me, heard me talking about it with someone at the farmer's market, said, yeah, same things happened to me. It was on and on and on. So it's thanks to Artie, we've had, he got us out of the worst of it. I was pretty depressed at that point. He's been very helpful to get things moving back where they should have been and got things to you. So we'll do better, but just keep in mind that maybe it's not your area at all, but there needs to be a little more cooperation between the zoning enforcement people and administrators and the people who live and are doing things in Rhinecliff. So appreciate you guys' help and especially yours.
Well, Mr. Navras, I just want to say I apologize for the experience that you have. No one should have to have that experience. We don't want people to have that experience. You know, obviously we didn't have anything to do with it, but I can tell you on behalf of myself, and I believe I speak for my board members,
Absolutely.
that this is very unfortunate and we're very sorry it happened. I think because of recent events, it will not happen again in the future. And so hopefully, the people in Rhine Cliff and the people in the town and the village of Rhinebeck will be more satisfied with the service they receive from their government officials. One thing I would note, though, just, and it has nothing to do with this, Rhine Cliff, just by its nature, you know,
Special problems.
it has special problems. I mean, you sneeze and you need a variance in Rhine Cliff. And we've seen that all the time, and we've routinely granted those variances because it made sense, and it's just a product of the law in 2009. But that aside, that's not this, and again, I apologize for your experience, and
And thank you, I appreciate that. I do know that this board and the planning board has been helpful and cooperative, but the process is very complicated. And I represented importers before the U.S. Customs Service for quite a few years, and some of those were pretty unpleasant situations. But what Customs eventually learned was that they did a lot better by talking to people before they hit them with these draconian penalties that they can't issue, and find out what's going on, and then see if they deserve those penalties or whether it can be worked out earlier. So,
I agree, communication is key, and hopefully, I know it will improve.
oh, you guys have been fine with those, so, thank you.
Well, thank you.
Thank you.
The board members have, oh, I'm sorry.
Finish up
Mr.
by-
Yeah,
by
sure,
saying
absolutely.
that Given the circumstances, we were hoping that the board could take some action tonight. We've been held up now for about 5 months on construction, and would like to get started again and not wait a month. If there's any way you can make a determination one way or the other on this, we'd be appreciated.
All right, I think closing the public hearing would be prudent at this point in time, unless anyone else wants to be heard. Okay, at this time, I would make a motion to close the public hearing. Do I have a second?
Second?
Okay, all in favor? Aye. All right, Mr. Lyons, you have a course of conduct or action here?
Well, I do understand the desire to make a decision tonight, and I know that this has been held up for a long time. This decision, I think, for reasons of precedent, the decision has to be one that stands up and makes sense. My suggestion would be that Kim and I can, well, you can talk about the decision tonight, and we'd like to get your input. I mean, I think I already have a sense of what the board members think about this. I'd like to get that, and then in between now and the next meeting, present you with a draft decision for the board's consideration that would be, hopefully be able to be issued at the next meeting. So,
Well, maybe I can start the ball rolling if we're going to talk a little bit about how we feel about the situation.
Yeah.
I mean, for me, I don't see how any of the other parcels have anything to do with the stop work order. So I have
Yeah.
no problem.
Yeah, I mean, I guess,
with the
if
decision
you
say-
want to issue a decision maybe on that.
I mean, to me, that's just a bare reading of the stop work order, and just looking at the survey, I don't see how a legitimate argument can be made that the other properties are affected by,
included in that.
are included in 4 Corning Street. So to me, that's just a no-brainer. As to the sufficiency of the stop work order, I don't know, because I don't
Yeah,
do
that's
this work.
That's the stopper really for me too, because we haven't, we just haven't drilled down on this, before tonight's meeting. I didn't know whether this was going to get, I knew that there were discussions going on. I didn't know whether it was going to get settled. And,
But we were hoping for that, but obviously that didn't happen. So I would have no problem, at a minimum, indicating to the extent that the ZEO, his determination that the other 2 parcels are subject to the stop work order of 4 Corning Street, that they're not. But I defer to you as our counsel as to whether we can make that determination, and then, leaving the other issue of sufficiency for Corning Street, that's not as immediate and can be addressed maybe at the December 20th meeting.
Understood. What are the other board members?
I concur with that. At a minimum, the stop work order should apply to no other lots other than 4 Corning. But I feel stronger than that. I feel that the stop work order should be determined to be invalid in light of what I heard tonight and what I've read. A stop work order to me is that you've done something wrong, and I see nothing that was done wrong here. Mr. Nemers didn't mention financing, but, if you go for financing, these type of things don't bode well in those circumstances. Even in the community, a stop work order, it's as though the town was ignored or the wrong behavior, and I strongly feel that this stop work order should be annulled, voided, whatever's necessary.
That's my feeling, but I just don't know if technically it's correct. I mean, so that's just my concern, because I just don't know.
Tim?
I agree with Richard.
Okay. Dave?
Yep, 100%.
On both points?
On both points.
Okay. Well, do you want to act tonight then, on both issues?
I have no quarrel doing that if you feel comfortable with it. I absolutely.
Well, I'm just going to tell you that, we didn't research it. With regard to the sufficiency, I am in general agreement with the board members with regard to which lot the stop work order
Yeah,
should apply.
that at a minimum, I think we have to do tonight. And
I don't want to over-engineer this either. I don't know that the board has been able to ascertain that there's anybody else out there that, we always want to issue decisions that, we're sure that the decisions are going to be standing up if they were ever to be challenged. I think the likelihood of a challenge being raised in this instance is probably not that great. And then there are other interest of justice issues that favor moving in an expeditious way, so.
I can't imagine any of the Supreme Court judges saying that we did something wrong if there was an Article 78 or
Yeah.
something or other with regard to taking the other 2 parcels away from the stop order. I think that's just an absolute. Again, as to the legal sufficiency, I don't know, but
I can't tell
Well,
you.
if I
but-
may interject an opinion on the sufficiency of the stop work order. As was presented, there has been remediation taken by Mr. Nemers. The site visit by Richard and Dave and Catherine kind of confirmed that it's going well. And then from John and my conversation with Michael, he seemed satisfied, and his question was regarding, if it was perennial or annual. But anyway, it seemed like it was certainly going in the right direction. So with the stop work order, where a lot of it was regarding the regrading and the clearing, it certainly is, whether, if it was sufficiently stated or not, it certainly is in the mitigation stages.
well, it's moot at this point, too.
Yes.
So maybe we don't even have to get to the legal determination and just say it's been remediated and it's moot, because that's what the site visits have shown and all the evidence that we have. So
Well,
we don't even
why
have.
don't, if that's what you want to do, I think Kim's point is a good one. And I think that if that's what you want to do, why don't you state 2 separate bases for making your determination that the stop work order is not valid as of this date? And one is, you already stated some concerns you had about legal sufficiency to start with, but the second issue is that it would appear that the actions that have been taken by the applicant, the evidence that's been presented, plus the site visit, the evidence that's been observed in the site visits by 3 members of the Zoning Board of Appeals, all indicate that, in addition to some evidence that was presented today, indicate that the situation has been mitigated to the board's satisfaction, to the point where it invalidates the stop work order.
Right, so you want me to make a motion and try to articulate that?
Yes.
Thanks. I knew that was coming.
Chris, it's up to you. I would suggest that if you're going to take action on these, that you should take separate motions to address
Okay.
the two questions that are.
Well, as, the easy one in my mind is that, it's clear that the stop work order, by its very terms, the four corners, reading the four corners of the document, it only deals with 4 Corning Street. So I would make a motion that a finding be made by the Zoning Board of Appeals that the stop work order at most applies only to 4 Corning Street and does not apply to the other 2 parcels.
Okay, that's a motion.
That's a motion. Do I have a second?
Second.
Discussion. Okay,
Poll the board?
please.
Okay, Susie Albert?
Aye.
Yes?
Yes.
Yes.
Okay, and the second motion I make is that I don't know that the Zoning Board of Appeals has to get into the issue of legal sufficiency of the notice, in that it's clear from the testimony of the applicant, from the site visits from the board members, that the stop work order has been rendered moot by the remediation done by Mr. Nemers. And,
Could I
Sure.
insert one thing?
Sure.
I would take it even one step further to say that the stop work order could prevent further stabilization. So I think it's in our interests to allow the landowner to actually restate or reinvigorate his.
Can you expand upon that explanation?
Nullifying.
if we
By
nullify it,
nullifying the stop work order, yes. Sorry.
so you have a slightly different motion. I say we don't get to, which believe me, I'm not
Either way.
wedded to my position,
Yeah.
but you're saying we ought to nullify it based on what grounds? One, that
Based
it's,
on one, that it's moot, the property is stabilized, and the stop work order only goes to essentially stabilization.
so it's been met.
It's been met. And 2, any further steps at stabilization cannot be undertaken until the stop work order is removed.
Okay, so let's.
You know, David, we don't have to nullify it. I think, I would prefer to go with Scott's, where it's gone, and that's the end of it.
That it's been satisfied, so to
It's been
speak.
satisfied, yeah.
Okay?
Which is nullifying it, kind of. It's been the requirements have been satisfied based upon our site visits and the evidence presented. Mr. Rodenhausen, do you have a,
It's just that, going back and forth with Mr. Evangelista, he kept adding requirements to it. As long as the order was in effect, he wanted professional engineers to do drawings of all sorts. It got very complicated. That record is still there. We need to have the order lifted so that no longer applies to us. To say that we met the requirements doesn't lift the order, and I think Mr. Tobias is correct that as long as the order is there, we can't do the things that we would do in the property.
I disagree.
Let me-
I think
It prohibits any action by.
well, let me ask you this practically. Are you going to do anything with regard to stabilizing of the bank between now and the 20th?
We've been advised by both Loveland, Dennis Loveland, and by Heather Whitehead, who's done a lot of properties around Rhine Cliff. She says a couple of were even more steep than mine. She did the bank on, just for an example, was my model. The one for Sue C's house on Grinnell Street. Beautiful job. I've never intended to go to all that expense, but I did plan to put decorative grasses, things that would.
But when was the plan for this? Is it between now and December 20th?
No,
Assume-
we can't, it's too late.
Right, and that's what I'm getting at. So we would have, I think, there's not going to be any more stabilization done, so maybe, we do have a window where we can do something more formal on the work order. And you're still going to be able to go forward. You're able to go forward at this point in time because we've detached the 2 properties from the work order.
Most critical.
Correct. So that's taken care of.
We don't want to be restricted on what we can do on the slope once it warms up again.
Right, but we will take care of it by the 20th, I can assure you.
Well, we would have to
December
because
20th.
we closed the public hearing anyway.
Right.
Yeah.
So we have 62 days to issue a
I guess my concern is just that we can't control the weather, so if there is some major storm that creates an erosion problem, Mr. Nemers has his hands tied between now and the 20th. So I guess it just seems to me to be in the town's interest to allow whatever stabilization efforts might be needed, and maybe none are, to take place.
So what you should consider is the motion to lift the stop, because what you have the authority to do is you can modify or reverse decisions by the zoning enforcement officer, or you can do what you think the zoning enforcement officer ought to have done based on the facts as you have ascertained them in your review, okay? So it's within your authority to make a motion to say that we've determined that the concerns that gave rise to the stop work order have been mitigated sufficiently, and that the stop work order is lifted.
That's what I prefer.
That's fine.
Okay,
Exactly.
that's a
We'll
motion.
drag it out.
That's a motion. Since,
Chris has it.
yes, so would you like to, is that good
No,
enough?
that's it.
That's it?
That's it.
Did you get that?
Shall we do it again slowly? Okay. All right, any discussion? No? All right.
Who made the nobody made a motion.
David made the motion. I think he adopted the,
Okay.
your
Do we have a
appli-
second?
okay, so I'll second it. You made the motion based upon John's
Description.
description, explanation. Discussion? No? Okay.
I'll just say, I think it's in the landowner's interest and our interest. Right? Nobody wants to see that property erode. So, to me, this makes a lot of sense.
Okay. Poll the board.
Yes.
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 Okay.
All right.
Thank you. All right, Eveready, I have to recuse myself on the Eveready matter, so Richard, would you be so kind?
Do we have anyone here?
From the, on Eveready, I believe from the emails, there was an email from the Board of Health of Dutchess County that indicated that they're working on it, and that was it.
Yeah.
Well, there was also a letter that came in from a Village of Rhinebeck resident,
Yes, there's three.
Right, okay.
Oh, that's this email.
Joe Lopez.
There's a concern email.
Is Scott recused on this? No.
Department of Health, and you have that too.
Yeah,
Okay.
and from MA Day Engineering.
Yes, and the engineering, so then you should have three things.
So this was the official status report from MA Day.
Such as it is, yep.
Yeah.
Yeah. All right, I'll go through it briefly. I did see it before. Yeah, it doesn't contain too much. This is October 23rd from Brian Watts, MA Day Engineering. And then attached is a County of Dutchess, September 27th letter from their health engineer, from Peter Marlowe to Mr. Day. And they have, the County of Dutchess has implemented a submission pre-screening protocol. No further action will be taken by this office until the following issues are resolved, and provide a complete application, secret documentation, New York State licensed professional signature, and is the nearby village of public water supply accessible for your project. So the hearing is left open until such time that they may require approval from the Dutchess County Department of Health regarding arrangements for the sanitary sewage and water easement. And I believe they're treating it as new construction, and that's basically it.
Yep.
Okay, so there's no action to be taken?
No.
Are we at a public hearing that we're extending? or-
Yeah, we are.
Okay.
And here's, Richard, what I wanted to propose in terms, so this has been sort of being continued over again and again, and it also, in the process of doing that, it's beginning to, at least for my part, it's fade in my memory. You know, Kim and I we had a meeting before we came down here, and when we came to this application, we really decided that there was a need for us to kind of refresh our recollections about the relevance of the issues that are being faced by this application at the planning board and how that affects the ability of the zoning board of appeals to make a decision on this. And then also what to do going forward. And I think that we discussed at one time as well, we had a similar issue that was presented at the planning board by Red Wing when they came in for a special use permit for their mine, and they were unable to demonstrate to the board that they had access to the mine from the town road. And things got tabled as they are here while other things went on, and we had a similar situation where board members are saying, you know, how long are we going to keep the application open? So in that case, what we ended up doing at the planning board was we said, all right, applicant, you have until X date to come forward with some proof that you've satisfied the application, you know, what we're looking to see, and if you don't, then we're going to have to deny the application. I think what I'd like to do, with your permission, is between now and your meeting on December 20th, let Kim and I do a little memo for the board that we'll go back and look at the application, we'll verify what's going on at the planning board, we'll figure out what our recommendation should be to you as a board to whether the Dutchess County Health Department issues on this bear on the variance and whether you should be going forward. And whether there's more information that that the board should be getting from the applicant. And then we'll present a recommended path forward to the board, whether there's nothing really holding us up here. You can just go ahead and look at the variances, or maybe we'll be saying, yes, this Department of Health information is germane to the issue that you have to decide. And because this has been kicking around, let's say, you know, the applicant has until maybe the February 2018 meeting of the board to come through with some additional information. And if not, then we're just going to deny the application as being incomplete. And if they'll have to reapply then if they...
Or is there any possibility that the board could proceed and then make it subject to? Anything we granted is
yes,
subject
we'll look at that
Yeah,
possibility.
Speaking as one member, that's the direction I'd like to go into, so that.
I know, I think the thing that's been a concern to us is
Yeah.
whether the plan for this project at the planning board is apt to change as a result of the Department of Health
Oh, I
review,
see.
because the location of the septic and
Yep.
all that and the water supply makes a difference to where you have the
That's right.
structures and
Yeah.
things like that.
Okay, I hear
So-
you. Yeah.
So what I would like to do is to propose that the public hearing be continued to December 20th, to have the board task Kim and I just to do a refresher memo for the board and a recommendation for a path forward on this application.
Okay,
Yeah, sure. Hey,
And just as a citizen of Rhinebeck, I was just wondering, is there anything we can do about the site? I mean, can it be taken down? It's just horrible looking.
well, that's not...
Anything legal?
Yeah, that's not really a zoning board of appeals
No, I know.
issue,
I
you know.
just-
We're
just
just
a-
dealing with the variance here.
I know, but I think a
and-
lot of citizens out there look at that site, they drive by it, and it's been going on forever.
Yeah,
It's just something-
although, you know, from a property rights standpoint, I'm not sure that we're exactly regulating.
I know.
uh,
I realize.
I don't want to
It's just- it
name
was just
other
a question.
properties in
So
town
we can
that
say
are.
anything when we're up here, so. it's-
Yeah, I know.
I mean, look at Rusty's in Red Hook, they cleared it down, it looks great. I mean, it's all
Yep.
gone.
Yep.
Yeah, point well taken. I'll make a motion to continue the public hearing till December 20th, and I also, on behalf of the board, request that John's firm look into a recommendation as to where we're going with this, and then we'll look at that recommendation at the December meeting.
Second?
Thank you. All in favor?
Aye.
Okay.
All right.
We'll do that.
Good.
Yep.
Thank you.
If it please the board, could we just step back to numbers for a moment? Because I understand we passed 2 resolutions, but I think the second one really obviates the first, right? If we're nullifying the stop work order, we don't need to say that it doesn't apply to.
I would ask that we
Leave
just
it?
keep 2B,
Okay.
because part of the reason that the current zoning enforcement officer wanted the ZBA to issue a decision on this was to have a decision on the books here that the stop work order doesn't apply to properties that are not involved where
So we
the
want a
work is
precedent
actually
order.
going.
That's right.
I see.
But just piggybacking on that, I know we've made the oral, motion, and we've voted on that. I assume at some point it'll be reduced to writing, or does it have to be reduced to writing?
Well, it'll be reflected in
In our
the
minutes.
written rationale will be reflected in the minutes. We'll just ask Chris to be pretty scrupulous about reflecting the discussion and the rationale in the recitation of the minutes. in the minutes.
I just want to make sure that.
Send us a draft of it, we can take a look at it.
Yep.
and
Yeah.
We can add anything.
I just want to make sure, I mean, there is a precedential aspect to that, and I just want to make sure that
That makes sense.
in the future, we have something to hold on to, and maybe it might get lost in
Yep,
minutes and
yep.
what have you. So-
I don't think it's going to be as good as it would be if we issued a written decision.
Right.
But I also think in this particular instance, there was an interest of justice reason
And
to
time.
take action sooner.
Yeah.
Okay. All righty, and the last piece of business I believe we have this evening is Gonzalez, and we have a proposed resolution on that.
I have that in my hand, and
Would you like to lead us through that?
I will. I'm going to break the speed record for a resolution tonight.
Please do.
ZBA case number 945, Amori Gonzalez has appeared before this board several times. It was an appeal from the town of Rhinebeck zoning enforcement office, denial of June 13. The parcels are 18 and 24 Pell's Road in Rhinebeck with the ID numbers which are identified in the resolution. It's 1.75 acres in an RC5 zone. The applicant represented himself. The applicant proposed to move the common lot line that divides the two above noted tax parcels in such a way as to shift .206 acres from 18 Pell's Road to 24 Pell's Road. Currently, 18 Pell's Road is 1.21 acres, and 24 is .531 acres in area. And that it would result in 18 Pell's having 1.012 and 24 Pell's Road having .737. Five variances were required. First, on 18 Pell's Road, there were 2. Lot width and lot area, it went from 345, the variance requested is 55 feet, and it was a required 5 acres, it's 1.012, the variance requested is 3.988. On 24 Pell's Road, there were 3, similar to the other 2, but one is lot frontage, 175 feet, required 240, the variance is 65. Lot width, required 400, it's only 180, leaving 222 feet for the variance. And finally, lot area, .737, required 5 acres, leaving 4.263. So those are the 5 variances. The appeal was filed in a timely manner as indicated in the resolution. On July 19th, the board deemed the application complete. The SECRA requirements are set forth, which are 6 NYCR 6.175C12 and 13. Referrals, Dutchess County Planning Board, Planning Department, they responded, we determined it was not required, was not required to be referred to them. The Rhinebeck Planning Board, it was referred to them, and the board recommended the ZBA rely on its own study of facts, as they normally do. Count of Rhinebeck CAB is not required. Water advisory, not required. Site visit, Tim and I went there back in July 21st of this year, and we observed the surrounding neighborhood first-handed, the on-site conditions, property characteristics, settings, etc. Public hearing was on August 16th, September 20th, and October 18th. There were neighbors who attended: Richard Walcock of Four Pells Road, Robert Smith, 637 and 308. The public hearing was closed on October 18th. Consideration of 5 factors in the balancing test. If the variance are granted, will they cause an undesirable change be in the character of the neighborhood? We feel the answer to this question is no, because there will be no physical change to the property resulting in proposed common lot line relocation. There are existing one building on each lot. The only change is to the lot line. The lot physical layout will not be altered. Can the benefit sought by the appellant be achieved by some method feasible other than this? Well, we find this answer to be no. Since both lots are substandard, any change will require a variance. Is this requested area variance substantial? We find the answer to this no. Will the proposed variance have an adverse impact or physical and environmental conditions? We find the answer to this question also no, since there is no new construction is proposed. Given that there will be no additions or constructions, there will be no adverse impact on the physical conditions or the neighborhood. Minimal variance required, last one. Is the alleged difficulty self-inflicted? We find this answer to be yes, as we do in most variance applications. In addition to our review of the 5 factors in the balancing test, we must determine if these variance requests are minimum variance necessarily adequate to accomplish what is requested by the applicant, and that also preserves, protects the character of the neighborhood and the health, safety, and welfare of the community. We find the answer to this question is yes, since the common lot line shifts represents minimal changes to allow for the future sales of Lot 18 while protecting locations for sanitary fields and well locations. Based on analysis, the 5 factors discussed, we find that the balancing test favors granting the variances sought. We now, therefore, based on the facts above, we grant the 5 variances which I set forth above. The ZBA hereby grants the variances subject to the conditions stated. The granting does not absolve the applicant from having to secure any other permits or approvals. The area variance will be null and void unless the lot line approval is not applied for and granted within 1 year of this resolution. That's it.
Take a deep breath.
Yes.
It took much longer than I thought.
Any comments, concerns?
I have one comment, Richard.
Yeah.
Although I agree and intend to vote yay. On the 4th balancing test,
Right?
I guess I don't necessarily agree with the reasoning, since no new construction is proposed at this time, because I think our job is to reasonably expect future construction on lots that we're granting variance for. So for me, the reasoning is because the expected uses will be similar to neighboring uses with sufficient space expected for likely improvements. So
We could add that, that's
I'm-
fine with me, but they were here numerous times and they said there's a residence on each lot.
The only
That's
thing
what
they're
I
going to do is
observed.
the fence.
Yeah, yeah.
no, I'm just saying, but
Yeah.
in creating this lot, we
Well,
have to.
they're not really creating a new lot. It's 2 lots right now. They're just adjusting where the lot line is.
Right, but what we're saying here is that no new construction is proposed, and I guess I'm just feeling that we are creating a new lot, because we're creating a new bound, we're allowing them to move the line, that we need to expect, right, the implications of this new line are that there will still be construction on this property at some point in the future. So I'm just pointing out that for me, it's not that there's no construction that allows it to meet that test, it's that if and when it's built, it will look like neighboring lots, it will have similar space and expected uses, so I'm just saying, for me, that's why I'm buying into that.
Okay.
Yeah, I'm not,
I don't actually see where this language encourages or allows another house, another property to be built. It was a very small.
It's that we're
The nomenclature really that you want to use is not that you're creating a lot, you're creating a new lot configuration, okay?
you know, and so whatever new configuration we're creating, we're saying we're expecting it to be used for likely development, right? Nobody's.
no, I don't see that. I mean, and because
I think-
there isn't any likely development. I think the only thing that we may want to throw in there is that there is an expectation that, and according to the testimony, that a fence would be put up. So this adjustment affects where the fence will be put up. But there's no expectation of additional buildings or,
This is the lot line in question.
Right.
The only thing that really was done was it was
Yes.
sewed, inflected it a little bit.
Right.
So that is.
I stand corrected. I thought one of these lots was vacant.
No.
no.
Apologies.
No.
Okay, sorry.
But I think on, I don't know if we want to add anything about the fence that was mentioned, because that was the purpose, as I recollect.
Well, they can or cannot put up a
Yeah.
fence, that's their option.
Right.
I have no problem leaving it alone, but.
Yep, I agree. Scratch that. Sorry.
Any other questions, concerns?
I just want to have a quick comment, and
Okay.
I don't know if I can comment on this before the vote, but I just want to say, I think that with this particular application, the board was very attentive to both the desires of the applicant and the concerns of the neighbors. So I think this resolution is very well-written and is very well thought out. So anyway, just want to say good job.
All
And
right.
it's a good application of, it's mentioned in here, but the minimum variance required.
Right.
It's a perfect example of how that's,
Right.
how that
Because
can
we
be
actually got rid
applied.
of one of the variances.
Correct. You get rid of,
Right.
we get rid of one of the variances, and just dovetailing onto what Kim said, I think while the owners weren't thrilled, they were able to accept the amendment, and I think the neighbors maybe not were thrilled, but were able to accept it. And as they
real
say,
estate.
well, as they say, a good settlement, neither side is completely satisfied, and I think that was, what happened here, but I think they were generally satisfied, and they all came together and agreed on this, so that was nice to see.
Yeah, I think the,
Doesn't happen all the
I
time.
think the review process worked well.
Yeah. So with that said, Chris, would you do the honors?
So who seconded?
I'll make a motion to accept this.
And who seconded?
Second.
David?
Second?
Yes, sir.
Okay,
Right, so now vote, did you have?
Yes.
yes. All right, unless anything else, motion to adjourn?
Yes.
Seconded.
All right, we're out of here.
To use
Thank
a
you, Fred.
technical-